Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. We're back. And your girl's not happy. Your girl's not happy. And all I have to say is that it's too bad Ratchet Madness is over, because I've got a new contestant. This is Judge Kathleen McCarthy Naiman. And you know how I say Massachusetts is where your constitutional rights go to die? They're dead. It's just too late. They're dead. Here we are, Kelsey Fitzsimmons. Late last night or yesterday, Tim Bradl supplemented his motion to reconsider by submitting a letter from Kelsey's trauma surgeon. I'm going to show that to you first before I show you the judge's order on whether or not she was going to change Kelsey's bail conditions, because according to her doctor and everyone with a brain, it is impossible for Kelsey, after being shot in the chest by her fellow North Andover police officer buddy and undergoing 6 surgeries, it is impossible for her to breathe into that scram monitor testing tube to get tested for alcohol consumption 3 times a day. Here is what Tim Bradl filed yesterday. It's defendant's supplemental exhibit filing on her pending reconsideration motion. Kelsey Fitzsimmons respectfully files the attached doctor's letter from Jonathan Parks, MD, the trauma surgeon that attended to Ms. Fitzsimmons during her stay at Massachusetts General Hospital. In the hearing that preceded the pending reconsideration motion, the court expressed its concern that it desired medical evidence relative to Ms. Fitzsimmons' condition, and on the assertion that her broken ribs could impede the deep breathing necessary for the scram device, causing pain and trauma to the defendant. If you did not listen to the court audio with me of that hearing, please go back and listen to it. I posted it on Saturday night during the live stream, in which I did a recap of Turtleboy's and Auntie Deb's Wilbur show. And then we played at the end Kelsey Fitzsimmons' court audio hearing from last week's hearing, when the judge decided to revoke Kelsey's bail and cuff her and put her back in jail. When I read the court order to you and I said to you, I haven't heard the recording yet, and they're not putting it on Zoom, so I'm just going to read to you the judge's words in the way that I think the judge said them, her tone. We were shooketh when we heard the recording of the hearing because the judge's tone was so much worse than we could have even imagined. What evidence do I have that she's got broken ribs? I'm sorry. Did you miss the fact that she was in the hospital for 53 days after she was airlifted from the scene in which she was shot in the chest by who I can only think is maybe the judge's buddy, Officer Noonan, who came to serve her with an order, took her baby away, and then said, oh, by the way, your baby daddy's filing for full custody and he's downstairs and he's here. So we're going to give the baby to him. It's horrifying. What proof do I have that she's got broken ribs? Bradl's document goes on to say the defense has obtained a letter from her surgeon addressing these concerns and corroborating Ms. Fitzsimmons and her mother's previously filed affidavits, and files a true and accurate copy herewith. There is no request for impoundment. Footnote 1 says, because the judge said, remember the judge said it, if you were with me for the recording, she said, I'm not going to give the probation officer's email any weight at all. It's hearsay. I give it 0 weight. And then it turned out the probation officer was in the room. And so the judge took testimony from him. And then he even tried to explain himself for some more. And the judge said, there's no question in front of you. Nobody's asking you anything right now. He tried to say, Your Honor, I watched her try and do this breathing test, and I could see that she's in obvious pain. But I don't want you to think that I'm saying she shouldn't have to do alcohol monitoring. I'm just saying, there's other ways to do it. Like she could go somewhere and pee in a cup, because when the judge found out that these breath tests breathing into the little tube in the scram device were scheduled 3 times a day for certain time periods, she said, wait a second, I thought they were supposed to be random. What do you mean they're not random? And he said, well, this is the way we always do it. And then it turned out her order did not say they had to be random. And then, if she was required to go to the place and pee in the cup, it would be random because they would just call up anytime they wanted to and say, hey, come on down. But the judge didn't want to hear any of that. Footnote 1 says the Supreme Judicial Court has always allowed the use of hearsay at probation revocation hearings. Commonwealth versus Durling, which is a Massachusetts case from 1990. See also Commonwealth v. Calvo, 1996. Unavailability of witness not required to be shown for admissibility of reliable hearsay. The revocation process, quote, should be flexible enough to consider evidence, including letters, affidavits, and other material that would not be admissible in an adversary criminal trial. I'm sorry, Judge McCarthy Naaman. Is this your first day? Is this your first day in deciding people's lives and whether or not they should go back to jail and whether or not they're dangerous under the law? Are we forgetting that the grand jury that was convened to try and indict Kelsey for attempted murder with a weapon failed to do so? And that the only charge remaining is assault with a weapon, which is a maximum of 5 years? She's a new mom. She's a police officer. She's 27, 28 years old. She's been through 6 or 7. Actually, she had to cancel her 7th surgery last Tuesday because you wouldn't allow the ankle monitor to be put on post-op. And the doctor wouldn't do a surgery with an ankle monitor on. Are you descended from the witches of Salem? Is that why you sit in the Salem court? I am fired up. I am so mad. I am so mad. I'm sorry. I don't mean to be mean. Don't think if I'm not taking it out, I'm yelling with you, not at you. Similarly, the Supreme Court has sanctioned the use where appropriate of the conventional substitutes for live testimony, including affidavits, depositions, and documentary evidence. Wherefore, the defendant requests that an alternative means of alcohol testing be implemented, such as urine testing at Our Health Systems, a Commonwealth vendor, 10 minutes from defendant's family residence. and that the defendant be returned to her previously allowed terms of release. Also, if you didn't hear the court audio, at the very end, you can hear Kelsey's cries. You can hear her crying. Here's the letter from her surgeon that was attached as an exhibit to this pleading. And anybody who knows anything about medicine, and even if you don't, the letterhead says Massachusetts General Hospital Trauma Center, Harvard Medical School. Dated September 15th, 2025, regarding Kelsey Fitzsimmons. To the Honorable Court. They didn't ask for redactions, but I'm going to redact this. Oops. Well, I'm trying to anyway. I was the trauma surgeon on call when Ms. Fitzsimmons was admitted to Massachusetts General Hospital with multiple gunshot-related injuries. Did I mention that she was airlifted from the scene? You know, in a medevac helicopter? Her documented injuries included gunshot wound to the right hemithorax with retained bullet fragments in the right upper back. Two, moderate right hemothorax requiring chest tube placement. Three, right middle and lower lobe pulmonary contusions with active bleeding. Four, grade 4 hepatic trauma with active bleeding from the right hepatic lobe. That has to do with her liver. She was supposed to have surgery on her liver last Tuesday. That's the one they had to cancel. Comminuted right posterior 12th rib fracture. Right anterior 11th rib fracture at the costochondral junction. Her treatment course included multiple procedures, including chest tube placement, percutaneous drainage of a hepatic collection, and ERCP with biliary stent placement. In my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement, such as deep breathing. Please contact me with additional questions or concerns. Respectfully, Dr. Jonathan Parks. Today, although the judge considered these papers that we're looking at right now, the judge has just issued her order. It is hot off the press, and it's 8 pages long. Are you ready? Buckle up, buttercups. It's a cold read for me. I know the outcome, but I didn't read the whole thing, so excuse me while I highlight as we go along. Essex Superior Court, Commonwealth versus Kelsey Fitzsimmons. Order on defendant's motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing. It would be nice if people didn't spoil it for those who don't know the outcome yet. Thank you so much. The defendant, Kelsey Fitzsimmons, stands indicted for 1 count of assault with a dangerous weapon. That is her only remaining charge. That is the only charge that the grand jury indicted her on. She's facing up to 5 years in prison. I want to remind you, Karen Reed was indicted and tried for for second-degree murder. She was not released with an ankle monitor. Karen Reed's charges also included drunk driving. And yet, I don't think she was subject to alcohol testing. I could be wrong, but I don't think she was. I don't know why is my highlighter not working? Following 3 hearings in 2 weeks regarding conditions of release pursuant to General Law 276, the case is now before the court on Fitzsimmons' motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing, paper number 24. As there is nothing in the motion that was not known to Fitzsimmons and her counsel when this matter was last before the court on September 11th, 2025, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's decision pursuant to General Law 276 or Massachusetts Rule 13. As explained below, Fitzsimmons' failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure the safety of all other persons in the community as required by Section 58A. Thus, the motion is denied. Let me read between the lines with you here. You're wasting my time. How dare you request 3 hearings in 2 weeks? How dare you waste my time? I'm running out of ways to tell you guys how not normal this is. This is not the way real courts operate. This is not the way that real judges operate. This shocks the conscience. This outrages me. Fitzsimmons' failure to transparently provide information related to her ability and willingness to abide by the conditions. She didn't know how difficult it was going to be to blow into that blow and go machine until she did it. And she tried to do it. And she did do it. And the tests were completed and she wasn't in violation. And Bradl said she would continue to do it, but she can't do it without pain, Your Honor. And because of that, it's cruel and unusual punishment. And maybe we could consider a less restrictive way, or less painful way for her to comply with the alcohol testing. But he never said she was not willing to. Despite 3 lengthy hearings, is the manipulation of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure the safety of all other persons in the community. I'm sorry. All other persons in the community? She was a danger to herself, Your Honor. She was a danger to herself. And do you really think you're helping here? Do you really think you're helping here? I just want to suggest to everyone that when we're done here, and you need something to pick you up, to go on YouTube and Google Judge Frank Caprio and watch Judge Caprio's greatest moments. I did that the other day when I was feeling down. And it made me remember that there are good judges. There are good judges. Please go watch it. It made me cry. There were people who came into court just with parking tickets and they couldn't pay. And one guy walked 10 miles and the judge gave him money for an Uber home. And he has he has a Philomena fund named after his mother. And he has money in there. And like people come in and they can't pay. And he's like, listen, there was a 95-year-old man who was driving his son who had cancer for blood tests. And the guy was like, listen, I'm so sorry. I didn't mean to speed in the school zone. I was driving my son to get his blood taken because he has cancer. I mean, this is inhumane. It's horrific. It's horrific. Background. After the Commonwealth moved to hold Fitzsimmons as dangerous pursuant to GL 276-58A, I just need to take this down for a minute and show you this instead. We'll just switch out the screen for a second. I have Kelsey's Give, Send, Go in the chat. If you can afford $1, $5, whatever, to try and help Kelsey, because I'm out of words to describe to you how horrific this is. Here's a picture of Kelsey and her former fiance, Justin, the firefighter from North Andover. Here's something that the North Andover Fire Department posted October 2nd of 2024. Our North Andover Fire Department family grows once again. Congratulations to firefighter Justin. I'm going to butcher the last name. I don't know how to pronounce it. Aylaian. I have no idea how to pronounce that. I'm not even going to try. And his fiance Kelsey on their engagement. That's when they got engaged, October 2nd, 2024. Their wedding was scheduled for October 4th of 2025. And there's Kelsey. Does she look dangerous to you? Does she look dangerous to you? And there's Justin, baby daddy, who went behind her back, got a 58A order against her. Told the judge in the probate court that Kelsey was dangerous and she threatened to harm the baby. He's the one who got the order on her. He's the one responsible for having, her 3 fellow officers show up, all men, by the way, take the baby away. I don't know if he was waiting in the car, in the getaway car or whatever, and, file for full custody because, let's think of it this way. If he gets full custody, he doesn't have to pay child support. She does. I really don't know anything about him, but I'm just, been around the block a couple times. I've seen how these things go. And Kelsey did not have an opportunity to be heard at that hearing where the judge heard only from that guy and maybe a couple of his family members or friends that maybe hate her based on allegations that she got too drunk at her bachelorette party. Come on now. Come on. That's what we're doing now? None of her charges have anything to do with alcohol. Not to mention, Officer Noonan, isn't it fitting that his name is Noonan? And that's the joke in Caddyshack. Right? Wasn't that from Caddyshack? Noonan, every time the guy tried to make him miss a putt. The judge is very concerned about the safety of the community and Officer Noonan, who's the only witness that claims that Kelsey turned her gun on him because they don't have body cams at North Andover. And one of you sent me something very interesting wherein they had a budget for body cams at least a year before this incident. But maybe the chief of the department, maybe Charlie Gray, maybe he doesn't want body cams for whatever reason, because we don't do body cams at North Andover. Oh, I'm fired up. We got to worry about the safety of Officer Noonan, my friends. Here's Officer Noonan. Think Officer Noonan is afraid of Kelsey? Here's a Facebook post from the North Andover Police Department from August 5th of 2024. Chief Gray and the North Andover Police Department would like to welcome back Officer Pat Noonan. Where did he go? Where did he go? Why did he leave? To our ranks. Officer Noonan has almost 20 years of police experience between North Andover Police Department and Lawrence Police Department. Why did he leave North Andover and go to Lawrence? Anyone? Anybody know? Great to have you back, Officer Noonan. Okay, here's Officer Noonan. Do you think Officer Noonan is afraid of Kelsey? Anyone? Here he is getting pinned or whatever. I don't know what they call that. I'm sorry. I don't mean to disrespect officers because I back the blue 100%. The good ones. And there are lots of good ones. Just like there's good priests, there's good lawyers, there's good doctors, there's bad ones in every profession. Okay? He's pretty big. He's pretty jacked. I don't know how old he is, but look at him standing next to his fellow officers at this same ceremony. Do you think that he is the one who's afraid of Kelsey? Because I don't. Mel Klomp said, I read it was the brother and sister who gave the information. I don't know where you read that. I don't know. Because when we went over the petition for custody, the only stuff that that I was able to obtain was stuff with his name on it. Oops, I just yeeted everything off my screen in my anger. All right, back to the papers. I'm going to try and keep it together for you. I'm going to try. That's just page 1. Background. After the Commonwealth moved to hold Fitzsimmons as dangerous, pursuant to 58A, a statute that we have come to know far more than we would like, the court concluded following a hearing on August 29th of 2025 that the Commonwealth met its burden as to dangerousness and that Fitzsimmons's release on personal recognizance alone would not reasonably assure the appearance of the defendant as required or would endanger the safety of another person, police officer Noonan, or the community. Rather than hold Fitzsimmons in custody, the court sought to fashion the least restrictive conditions of release that would reasonably assure her appearance and the safety of all other persons in the community as required by GL 27658A. Need I remind you again? She's a police officer. She's a new mom. You think she's just not going to show up to court? You took her baby away. You think she's going to abandon her baby? Does she have a record of not showing up? In what world is this judge living? Where are we? Aside from the inside out, upside down Narnia of Massachusetts. Based on the serious nature of the allegations against her, as well as the evidence presented by the Commonwealth about Fitzsimmons' history of aggressive behavior while intoxicated, I'm sorry. We must have missed that. She got drunk at her bachelorette party. In Maine. The baby wasn't there. If that's even true. The court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community and imposed that as a condition of release. The court imposed a number of other conditions, including GPS monitoring, that Fitzsimmons reside with her mother and stepfather at their home under house arrest, and that she have no contact with the victim, any witnesses, or her child. No contact with her child. House arrest. Assault charges, facing 5 years. I feel like at this point I need to apologize to Judge Cannoni. I feel like I never thought I would say this, but do we need to apologize to Judge Cannoni? Karen Reed wasn't on house arrest. Karen Reed didn't have an ankle monitor. Karen Reed was allowed to drink, and she was charged with offenses involving drunk driving. Why does it vary so much from county to county, from judge to judge? Why is there no consistency? I don't know. I don't know why. I can't answer those questions for you. I just can't. After a further hearing regarding conditions of release on September 8th of 2025, Fitzsimmons was released from custody. Okay, here's the timeline. Remember, because on August 28th, that was the hearing, right? August 28th, the dangerousness hearing. It was reported to the press and by the press that Kelsey was being released that day to the custody of her mother and stepfather, right? And that's what I said. Oh, good, she's going to be released today. Everyone said she's being released today. And the next day, even the reporters said, the news, all the local media said she had been released to her parents. But no, the judge tells you right in her order, she didn't release her until September 8th, when they had another hearing. Because, for what reason, I don't know. The judge had to, do some things and stuff. And, Labor Day weekend and all. Does she go to the Cape too? I don't know. Wait, somebody here also says she was breastfeeding. She was breastfeeding too? I didn't think I could get any angrier. I really didn't. This is Judge Kathleen McCarthy Neyman, Neyman. After a further hearing regarding conditions of release on September 8th, 2025, Fitzsimmons was released from custody. In the 3 days that followed, Fitzsimmons requested relief from 2 of the conditions of release to which she had just agreed. How dare she? How dare she? First, immediately after the September 8th hearing, defense counsel requested that the GPS condition be lifted so that Fitzsimmons could undergo surgery the next day, September 9th of 2025. How dare she? How dare she try and have her liver repaired by a surgeon? With no evidence to support the contention that Fitzsimmons could not wear a GPS device during surgery, and based on probation's representation that a GPS device does not always need to be removed for surgery, the court denied this request. I'm sorry, probation said that a GPS device does not always need to be removed for surgery. Yeah, maybe if you're having a tooth pulled, maybe if you're getting a root canal. 2 days later, Fitzsimmons filed an emergency motion for immediate relief from scram order, which sought relief from the court order requiring her to breathe into a scram device because Fitzsimmons was, quote, unable to do the testing without experiencing severe abdominal pain and dizziness, and because, quote, the breathing necessary to the task is impossible in her condition and impairs healing of her broken ribs and punctured lung, end quote. Do you think the judge didn't? I mean, obviously the judge didn't believe that. At a hearing on that motion on September 11th of 2025, counsel argued that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the conditions of being monitored by Scram, but presented no alternative testing options to ensure Fitzsimmons remained alcohol-free. I call for the bullshit button. Not only did he attach an email, which the court refused to consider, from probation saying that she could go and have a urine test, the probation officer was in the courtroom and testified. Faced with counsel's representations that Fitzsimmons could not comply with the Scram testing, again, bullshit. He said she could do it. It was just painful. A condition that was critical to the court's decision to release her on conditions and in lieu of incarceration. The court vacated its prior order of release and ordered Fitzsimmons be held without bail pursuant to 276-58A. That's the dangerousness statute. She's a crazy person. She's a crazy person. She's a crazy person. I mean, that is being kind. Andrea Clark, but she's a crazy person. We all watched that. Well, we didn't watch it. We heard it. We listened to it. We heard her tone. We heard her tone. And every time Bradl mentioned something involving the U.S. Constitution, like, due process or cruel and unusual punishment or the Eighth Amendment, she went berserk. She's like, oh, due process. Oh, she sounded like a demon. Discussion. In the specific context of persons held pursuant to 27658A, quote, the hearing may be reopened by the judge at any time before trial or upon a motion of the Commonwealth or the person detained if the judge finds that one, information exists that was not known at the time of the hearing, or that there's been a change in circumstances, like she can't breathe into the machine. And two, that such information or change in circumstances has a material bearing on the issue of whether there are conditions of release that will reasonably assure the safety of any other person or the community. Noonan. More broadly, Massachusetts Rule 13A5 empowers a judge to reconsider any pretrial motion which has been heard and denied upon a showing of substantial justice. Well, let's underline substantial justice 3 times. Because this judge's definition or interpretation of substantial justice is going to substantially differ from perhaps yours and mine. In this case, there is nothing in the motion that was not known to Fitzsimmons when this matter was last before the court on September 11th, 2025. Do I need to point out again? Nobody knew. She never had to do a blow and go before, Your Honor. It's not like she had this condition several times before on house arrest. And so she should know how long you have to blow into the tube and with what frequency and what duration and how hard the breath needs to be. Anybody ever have a fractured rib, a collapsed lung, a lacerated liver? Anyone have asthma or COPD? Have difficulty even blowing out a candle? Substantial justice. Put a pin in that. However, Rule 13A5 is not limited to instances where there are allegations of new or additional grounds that could not have been reasonably known when the original motion was filed. Instead, a judge always has the power to reconsider his or her own decisions during the pendency of a case. Put a pin in that too. Power. Judges are not condemned to abstain from entertaining second thoughts that may be better ones. Yes. Yes. Wouldn't it be better for her to pee in a cup than have to throw back her recovery who knows how long by putting her in pain and causing her to perhaps rupture something or, delay her healing a bit? Ultimately, whether to do so or not is a matter of judicial discretion, and a reviewing court will disturb a judge's decision on a motion pursuant to Rule 13A5 only when there has been an abuse of discretion. Well, honey, I think you've earned it. I think this is textbook abuse of discretion. Textbook. And is it a violation of the ADA? I don't know. Judges have immunity and wide discretion and power. Fitzsimmons' pending motion asks this court to reconsider its revocation of her release and instead impose available alternative alcohol testing by random urine tests as set forth in the attached email provided by probation. The attached email was purportedly sent by Assistant Chief Probation Officer Jeff January at 6:21 p.m. on September 10th, 2025, the day before the hearing on Fitzsimmons' emergency motion for immediate relief from scram order. Purportedly sent. If you have kids in your car or in your room, or you have me on a public television, please take me off. Put in your earbuds. Jeff January was in the fucking courtroom. And he got up and he swore to tell the truth. and he testified and we heard him. Purportedly sent by? I see how this is going to go. Armchair detective, do your thing because there is something going on here. In her court order, she says she doesn't believe that this court officer, the probation officer, actually sent the email. And he sent it the night before. Right. Because Bradl reached out to him and said, hey, dude, you saw how difficult it is for her to breathe into this thing. Are there any alternative ways to test her for alcohol? And he said, yeah, Tim, yeah. The only other thing we have is the random urine testing through this place, and she'd have to go there. And the email notes that the only alternative to scram testing is urine testing through a vendor called AverHealth, which would require Fitzsimmons to travel to one of the AverHealth sites to submit to a test. The email concludes by offering to provide more specific information on AverHealth tomorrow morning. At the hearing on September 11th, the court gave the parties ample opportunity to present their arguments. Mr. January was present and testified under oath. Oh, see, she remembers. For some reason, rather than bringing in the alternative testing option to the court's attention and inquiring about it with Mr. January during his testimony before the court, defense counsel at that time sought only an order completely relieving Fitzsimmons of the condition of release, requiring her to submit to scram monitor. No, that's not what happened. And in fact, I do not think that Bradl even questioned Mr. January. I think it was the judge who questioned him. And then when Mr. January tried to add some things, she said to him, and I quote, something like, there's no question on the table. Would you like to say something sua sponte? Because nobody's asking you anything right now. And that was in the email about the alternative testing. So you're going to blame it on Bradl? Maybe we should make t-shirts, blame it on Bradl. No, I wouldn't do that. That's not what he sought. He did not seek an order completely relieving her of alcohol monitoring. Here's the other thing. Scram, the company, because I've done my deep dive into Scram, also makes an ankle monitor that serves a dual purpose. It's a GPS monitoring system, and it's also an alcohol monitoring system because it measures alcohol through your perspiration. It does double duty. They don't have that in Massachusetts, apparently. Footnote 1. After hearing argument from the parties and testimony from Mr. January, the court asked defense counsel if he had anything else to submit. In response, he sought to admit into evidence a September 8th, 2025 email from Mr. January reporting his observations of Fitzsimmons during the scram installation, but not the September 10th, 2025 email from Mr. January or live testimony from him about alternative testing. I'm sorry. Do I need to fucking point out that the judge could have questioned him? She was the only one questioning him. I'm in another world right now. I'm in a on Runkle Stream, he said we could do a fundraiser to pay for that ankle monitor. No, but not if they don't accept that as a way of monitoring in Massachusetts. You think she's going to allow that when she won't even allow her to go pee in a cup? And she won't even allow. This is not the way it's supposed to be. Before taking a recess to reach a decision, the court once again asked defense counsel if he had anything else to submit, and he responded in the negative. Yeah, that's because you said you were giving zero weight to the email and it wasn't allowed to be in evidence because it's hearsay. It's hearsay. It's hearsay. It's hearsay. And she took her little time out and she went backstage with her grave concerns, and she drafted an order and came out and read the order verbatim. I don't know how long the recess was because because we only have the recording of it, and the recording cuts out the break, so we don't know how long she took to draft that decision real fast back there. Yeah, keep right, exactly. Scarlet Begonias is here. Oh, I will always allow a Grateful Dead reference. That makes me so happy. So, well, she says, why was she assigned to this case if she does all 7 cases? I don't know that answer, and that's not the comment that I was trying to highlight. But I do love your username. There was something somebody said. Remember that this judge is a woman, and doesn't that make it even worse? Right? Why would he submit more emails when she gives them 0 weight? Shortly thereafter, defense counsel vaguely suggested that there might be other alternatives that might involve Fitzsimmons leaving the house for urine testing, but never provided the court with the information contained in Mr. January's September 10th email or any other specific information regarding an alternative testing option that would allow the court to assess whether such an alternative option was appropriate in Fitzsimmons' case. I am also going to point out to you that the judge should be aware of all methods available to your county. Are we in another world? I think we're in another world. I think we're really in another world. Because Bradl's like, duh. You're supposed to know that, judge. I'm I don't even know what to tell you. I just don't even know what to tell you anymore. It was only after the hearing when the requested relief was denied that defense counsel brought the court's attention via the pending motion that Fitzsimmons could be tested for alcohol via a urine test performed by AverHealth. Rather than live testimony under oath from Mr. January on September 11th, defense counsel now asks the court to rely on an unverified email that provides little detail about AverHealth and the testing it offers. Footnote 2. The court declined to consider a September 8th, 2025 email from Mr. January's evidence at the September 11th hearing on the grounds that it was hearsay, and Mr. January was at the hearing and available to provide live testimony under oath. Well, here that's also necessary for the bullshit button to be used again, which I don't know where. Did I throw it? Did I throw it at something? She said that email is hearsay. I'm not going to even consider it. I give it 0 weight. And then someone said, well, he's in the courtroom. She didn't know he was in the courtroom. She didn't know it. She didn't know it. And in the interests of justice, shouldn't the court have asked if she's not aware of what's used in her state and county for alcohol testing, and he was there, the probation officer? Even Judge Cannoni would have said, is there any other way that she can do this? Even Judge Cannoni would have done that, because even Judge Cannoni was like, Mr. Lally, do you want to object? Mr. Lally, do you want to object? Well, Section 58A provides that the rules concerning the admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing. Oh, she must have went and looked up the statute after he brought it to her attention that hearsay is admissible at those hearings. For otherwise inadmissible evidence to be admitted at a Section 58A hearing, it must be reliable and there must be a good cause for the decision not to present live testimony. Good cause can be shown in 2 ways: by presenting a valid reason for not presenting a live witness, or by showing that the proffered evidence bears substantial indicia of reliability and is substantially trustworthy. May I just, is there anyone in the house? Anybody in the house? Yeah, you're in the house right now. You're in my house. Is there anybody in my house right now who lives in Essex County? If you live in Essex County, put a 1 in the chat. If you happen to live in Essex County, Massachusetts. The motion also implicitly asks the court to modify the condition of release, placing Fitzsimmons on house arrest except for medical, court, and attorney visits with 48 hours notice to probation, as urine testing would reportedly require her to go to an AverHealth facility with less than 48 hours notice. The court points out that when it initially outlined conditions of release at the August 28th hearing, the court specifically noted, in the context of considering whether it was necessary to require random drug testing, the importance of minimizing the number of times Fitzsimmons was allowed to leave the residence. Oh my God. Even Brian Walsh, who is accused of chopping up his wife and distributing her body parts in dumpsters in plastic garbage bags all over town. Even Brian Walsh is allowed to leave the house to drive his kids to and from school and go visit his mother. Shout out to the following residents of Essex County: Mrs. S223, Michelle Parquette, Laura, Tempestuous Patriot, KB1QHV, Jacqueline Pino, Mama Bug 107, Chrissy, Kelly Bell, John Cuncho, Danielle DeMeo, Elizabeth Parr, Warped Head, Lisa Gibney, Jody D, CW, Paul Fleming, Joanne Ramirez. Move. You got to get out of that county. You got to get out of that county. God forbid you or one of your family members winds up in front of a witch like this. God forbid. Miles King is out on bail. Joshua Hubert has been out on bail after he was accused of kidnapping, choking, and raping a 7-year-old girl and then throwing her over the I-290 overpass bridge in Worcester into Lake Quinsigamond. He's been out of bail since 2017. The jury is deliberating right now. They didn't reach a verdict today. Kay Willis. Kay Willis is the realtor. She's south of Boston. I don't know if she's here right now. He's in jail. Steph says he's in jail. He was out on bail before. Who is? I don't know. I can't go on a side quest right now. Cats of Chaos, you two, move. I need a chiropractor. After being advised by probation that Fitzsimmons would have to leave the house for drug testing, and because it was alcohol and not drugs that were of concern in Fitzsimmons' case, the court declined to impose drug testing and imposed only alcohol testing via a scram device because it could be done from the confines of her home. Read between the lines here. You're lucky I also didn't impose drug testing on you, because the only concern in your case was alcohol. I'm sorry, according to who? Oh, Brian Walsh? No, Brian Walsh has been in custody this whole entire time. Did I say Brian Walsh? Brian Walsh has never been out on bail. Oh, I'm sorry. Wait. He was. No, I'm sorry. You're right. Brian Walsh, after dismembering his wife. You're right. Okay. Thank you for correcting me. But before that, he was on home arrest. That was for the federal charges that he had, that he was selling fake Andy Warhol eBay paintings. You're right. You're right. I was wrong. I just got too fired up in my argument. You're right. After he was arrested, he's been confined. He's been in the confines of the Norfolk County Pokey. You're correct. But my other arguments were right? Joshua Hubert, Miles King has recently been let out. And I'm sure we can come up with a bunch of other examples of other people who've been let out on bail in Massachusetts. Again, the court continues to recognize the importance of minimizing the number of times Fitzsimmons is excused from house arrest for the sake of assuring the safety of the community. She's such a danger to the community, right? The court also notes that Fitzsimmons has had other opportunities to raise the issue of her inability to comply with scram testing and suggest alternative. Really, what other opportunities? She didn't know how hard it would be until she tried it. I'm sorry. Has common sense left the building? And compassion? Any knowledge whatsoever of injuries and gunshot wounds to the chest? The court first advised Fitzsimmons. I saw that you guys said Nurse Kim was in the chat. Kimmy, if you want to come on, I'll send you a link. Just text me and let me know. But I don't know. You could be driving or something. But I'm outraged. And this just dropped, so I had to. Kelsey is 5'2". The court first advised Fitzsimmons that her release was conditioned on being alcohol-free and subject to scram testing at the initial 58A hearing on August 28th of 2025. At that hearing, counsel asked questions and sought clarification about other conditions, but not about the scram testing condition. In addition, on September 8th of 2025, Fitzsimmons submitted to the court a medical notice, which the court impounded upon her request. Without revealing sensitive information, that pleading represents that Fitzsimmons has trouble breathing due to injuries sustained from a gunshot wound. Okay, so it wasn't impounded for the court. You're allowed to know about it. So now you're admitting that on September 8th, you were on notice because you had her medical records? You were on notice that she had trouble breathing? And then you act so surprised on September 11th when the hearing happens, you act surprised about it? Despite this, Fitzsimmons raised no concerns at the September 8th hearing about her injuries interfering with her ability to comply with scram testing. In sum, there has been no change in circumstances or newly discovered information that would warrant revisiting the court's decision pursuant to General Law 276, 58A, footnote 4, which says the court acknowledges receipt of defendant's supplemental exhibit filing on her pending reconsideration motion filed with the court on September 15th. That's what we just read before this. It does not alter the court's decision. She's saying she read the surgeon's letter. It does not alter her decision. Just in case we were confused and thought, oh, well, wait, maybe she didn't see that letter from the doctor about the, the hemithorax and the pneumothorax and the hemothorax and the liver lacerations and the fractured, comminuted, fractured ribs. Maybe she didn't see it. No, she did. She saw. Nor has there been a showing that substantial justice requires it. Ordering Fitzsimmons to remain alcohol-free and monitoring her for alcohol use with a scram device was critical to the court's decision to release her on conditions and in lieu of incarceration. Fitzsimmons has had multiple opportunities to advocate for conditions of release with which she could comply and which would satisfy the court's concerns regarding the safety of the community, as evidenced by the dialogue that has been taking place between Fitzsimmons, the court, and probation over the course of the 2 weeks prior to September 11th hearing. Well, Your Honor, you said you were letting her out on August 28th, and then it was like you took it back. There should have been no backsies on that, but you kind of took it back, and then you waited 10 more days, and then you let her out. And then she tried for 3 days to do it. She never failed the test. She never was in violation. But rather than to continue to do this with pain, you never would have known about this, Judge, unless Tim Bradl brought it to your attention. You wouldn't have known because probation was not going to report her to you because she was in compliance. And now she's blaming Bradl. There are no words. There are just no words. Her failure to transparently provide information related to her ability and willingness to abide by the conditions imposed despite 3 lengthy hearings is a manipulation of this court's efforts to fashion the least restrictive conditions of release that would both allow her to avoid incarceration and reasonably assure the safety of all of the persons in the community as required to Section 58A. For the reasons explained above, Fitzsimmons' motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing is denied. XOXO. Kathleen M. McCarthy Naiman, Justice of the Superior Court. So ordered September 16, 2025. What does that mean? Oh, that means that Kelsey's still in jail. That means that Kelsey is still in jail. And we don't know when she's getting out. You need to get loud. You need to get loud. Anybody who is feeling bored after, the Karen Reed saga ended and the Karen Reed trial ended and Karen Reed was freed and Karen Reed now is out on a 1 year's probation on the DUI or whatever the hell they call it, whatever initials you guys use over there in the Massachusetts nightmare. You thought you were bored? I think you found your next cause. I think you found your next person that you need to free. And she's not getting the help that she needs in there at all. At all. She's not. October 7th is her next hearing. That is something that was already on the calendar. Anyway, her favorite color is purple. Go. Be there. Support. Be outside the courthouse. You did it for Karen Reed. We coming. We coming. You know who says that? Coach Prime. Sco Buffs. Scarlett Begonia says it. We coming. Her parents must be beside themselves. She needs surgery. I've pinned the Give, Send, Go in the chat. If anyone has the willingness and ability to spare a couple of bucks, please do it. Tim Bradl's not free, and this judge is making more work for them. And that's how you can help, Tennessee Jed. That's how you can help. I don't even know what to say. I'm hoping some of these comments that are starred and that are in the column here that I'm going to read to you have some ideas. People are like, Adam Lally's resignation. Bo, she's our girl. Adam Lally did not resign. That's just her username. She's been to court on Brian Camp. She was at the Josh Hubert trial. Bo, the jury's deliberating on Hubert. They went home today without a verdict. They started deliberating at like 11:30. Bo is boots on the ground. She says, take the train into Salem. Mackenzie says, I had bilateral pleural effusions after a hip scope and wholly hurt with every breath. I can't imagine blowing into a breathalyzer with that. And I'm sure her injuries would make it way more painful. Carla Maria says they wanted to take this poor girl out. We need to help her. William Grant says we need the purple people to show up. I live in Canada, but I will be wearing purple for her court days. Someone asked this morning, how can we send letters of support? I suggested that if you wanted to send them, you could send them to Tim Bradl's office. Just Google his office address, mail them there. He will make sure, or Courtney, his amazing paralegal, will make sure that she gets them. Casey Brown became a new member. Welcome, girl. Gail says, abysmal attitude of this judge, wondering if she's a spinster and never given birth. No, I think she's married. Certainly lacks common sense and understanding. Very sad. Very sad. Sue says, I was doing research on this matter and the judge is violating the ADA. The ADA does apply to bail conditions. I'm absolutely livid, sending hugs, even in Massachusetts. Even in Massachusetts, because you know how everything that is allowed everywhere else is not allowed in Massachusetts. So I haven't had a chance yet to do the deep dive into this yet, of course, because everything keeps breaking so quickly that it never gives me a chance to get into the rabbit hole. But I've got Alice emojis for that because that's where I go very often. Call me Alice when I fall into the rabbit hole. Thank you, Suze. Audrey, thanks for your 20, says, as far as I'm concerned, the court should only be able to mandate routine testing for alcohol. Let the probation officials decide the best mechanism of how to do that. She's so much worse than Bev. I agree. Thank you so much for your super chat. Brigitte, the best judge. I am Rhode Island. He had the best heart ever. Oh, you're talking about just Caprio. Is it Caprio or Capria? Hold on. I'm losing my mind. Caprio. It is Caprio if you want to look up his best moments. I would play them, but I'll probably get stricken by YouTube or somebody. So he was the best. And he was from Rhode Island, right? Frank Caprio. So much compassion. A model of how every judge should be, in my opinion. Brina says, I love your passion. I'm here with you. Thank you for being here for 13 months. I get so angry. I'm an empath. It's not easy. Thank you. With a little technical perjury says, we are outraged. Free Kelsey all the way from Norway. She's outraged all the way from Norway. Thank you for the hashtag and for the Purple Heart. Mel said, I read it. Was the brother and sister who gave info? That I don't know because I don't have those affidavits. If anybody has them, feel free to send them to me. Allison Currington, thanks for your 10. Legal abuse usually is one of the first of coercive control post-separation. The partner not taking care of young children has too much time on their hands and resorts to harassment of this kind. Coercive control. Thank you, Allison. Aunt Bibi says, I must watch my words. Well, I didn't tonight. Kelsey has a breathing disability, whether it be for months or life, because we have a disability act. There's got to be something Bradl can do. Outrageous. Cursey emoji. Thank you, Mel. I love you, Aunt Bibi. And Manja, can't lie. This feels weird. I thought Kelsey is the victim here. Shame on her ex-partner not stepping up to help her. He knew her and what she was going through physically and mentally. Yeah, he also shot her in the chest. And, if the truth is, as Kelsey says, that she was pointing the gun at herself and not him, and he shot her in the chest, he could be in trouble, right? So, shame on him, but I think we've seen it all at this point. Esther says, thanks for covering this. Oh, well, I wouldn't be anywhere else, Esther. Thank you so much for listening. KLM says, so probation word was good on ankle bracelet, but not on the breathing issue. Yeah, apparently so. Aunt Bibi, of course I have no proof, but my senses are telling me someone is whispering into her ear. Anybody know? I don't know. Kelly says $102,000 was given to Andover for body cams in 2021. Kelly, are you the one who sent me that? I knew you sent that to me. So thanks for putting it in a super chat so I didn't have to go look for it. North Andover specifically, right? $102,000 in 2021. Thank you, Kelly. Charlie Lynn, there is no world where Kelsey gets a fair trial with this monster. Thank you for your super chat. Greg from Australia suffered 3 broken ribs, internal bleeding, and punctured lung 4 years ago. 12 days in the hospital, 6 months later, coughing still caused significant pain. She was in the hospital for 53 days. Martha Coakley, right, is on the defense team. She's the former attorney general for the state of Massachusetts. You think that's what's pissing off this judge? Do you think that's what's pissing her off? That Martha Coakley is involved in this? I don't understand it. Jen and Toxic doesn't understand it. I don't understand it either. And I try so hard to make sense of these things for you. I try. I have over 30 years experience. I just, as a practicing attorney in New York, of course, and it's a different world here. It's not perfect here in New York, but it's different. And I do not understand it. I cannot explain it to you. We'll look at 58A after we get through some of these questions. Calla Lilly says, this is incredibly scary. We happen to be discussing this case. I can't imagine all the other cases where things like this happen, right? And these are the cases that I pick to cover, that I choose to cover, because we need to talk about it. They need to be blasted. It needs to be blasted out there, because if it can happen to Kelsey Fitzsimmons, if they can come and take away her baby based on one guy's story, they can do it to you too. Can you imagine having your 4-month-old baby ripped from your arms while you're breastfeeding on the couch because some guy who you're engaged to and supposed to marry in a couple of months turns against you and goes into court and files for full custody and claims that you're dangerous? How many of you would lose the will to live? And throw on top of that postpartum psychosis or depression. I don't know. I can't explain it. It is so scary, Calla Lily. Thank you. Not that Dina says, behind district court is a paid parking lot that's big and fairly inexpensive. But it is October in Salem, so please get there early so you can park. See you there. Oh, thanks, Dina, for going. Thank you. Thank you for being my daily coworker. If you know, you know. Well, are you still working at 6:30 p.m. on the East Coast? One of my amazing moderators, Scott, 25 years on the job, NYPD, says he's changed his name to the most hated mod on YouTube because he doesn't put up with any of the bullshit. And he doesn't put up with anybody trashing me or other creators or anybody else, but I don't know where it went, Scott. I just had your comment and now I lost it. He said, in all of my years and in all of my training, I have never, ever, ever. Here we go. LawTube's most hated mod says, FYI, went through 2 police academies and there is not one procedure that says to cap someone treating to unalive themselves. Tracy Davis, could the ADA apply for her? Glama Sue says she looked it up. But I don't think you're in Massachusetts, Sue, so I'm not sure. We're looking into it. And that's what I suggested too. Craig says it's well known that broken ribs take ages to heal. Yeah, but not this judge. She wouldn't take judicial notice of that. Thanks, Renee, for becoming a member. I think I'm usually not this angry, so I apologize. Christy, a painter's daughter, says sending hugs, prayers, and donated. You're the greatest. Thank you, Christy, for been here for 17 months. OG. Audrey says, I wonder who's holding a gun to this judge's head. There can be no other logical answer for her behavior and rulings. I'm beside myself. Thank you for your 10, Audrey. Sharon Bell says, Kelsey dropped a harassment suit against the cop who shot her 3 days before the shooting. This stinks. That I was not aware of. It was against Charlie Gray. There was a lawsuit. I have a playlist on this. It's in the show notes. And I think that I have to go back and look at it. It may have been an administrative proceeding to get her guns back because she was cleared for duty. She had been on leave because of the postpartum depression. And I don't know if she dropped a harassment suit on Noonan. If you have that, if you have the receipts on that, feel free to email it to me. My email is in the show notes, but I thought I had done all of the deep dive on this. And that was against, I believe, the chief, Charlie Gray. And that was something to get her guns back. And not to say that Charlie Gray has not had harassment suits filed against him before by other female officers in the department. There's something like 40 officers in North Andover and only 3 of them are women. And there have been, we went over those other lawsuits, at least 1 or 2. So thank you for your super chat. KLM says, I'm not positive, but I thought I read that Kelsey has court next week for the baby. I think that's in probate court. I don't know if that's open to the public. If anybody knows, you can let me know. And I think that hearing, that doesn't mean that you can't be outside, but I don't think you can go in. It might be closed to the public, but that hearing is on the 23rd, which is a week from today. See you next Tuesday. That's not in front of this judge. It's in front of a different judge. And I do have some papers that were filed in that court. I think that's Lawrence District Court, right? Wait a second. So Bradl also filed, I have here, a motion to release ROR, but that was from August 7th. So, and that was filed in Lawrence District Court. So, never mind. I thought that was something filed in a different court to try and get around this judge, but it's not. So yes, you're right. You're right about that. Thank you, KLM. No love at the traveling trooper says, I have COPD and failed the test for breathing. I'm sorry. I know it's hard. Brandy says, I had 2 ribs dislocated when pregnant due to my son kicking me. So painful to take a breath and the anxiety of taking a breath. Ridiculous. Thanks, Brandy, for chiming in and for your super chat. Jackie says, severe asthmatic here. We are outraged. Free Kelsey Fitzsimmons. Mel says, the baby will have permanent damage from this. I mean, this is the most important time, right? Bonding. The bonding between a mother and her baby. She's not even allowed supervised visitation. Now she's back in jail. I'm beside myself. Music to my soul says, GLC section 276 58B requires violation of release terms to revoke bail. Am I missing something? Judicial discretion can't override legal requirements. I have to look into the statute and I'll pull it up and we can look at it together. But without me doing like a real deep dive, the best I can do at this point right now is pull it up and look at it with you. So let's take a look in a minute. Gray space. Remember earlier today when we were reading a well-reasoned decision from a normal judge? I missed that time. I missed that time too. That was Judge Gregory Caro in New York State Supreme Court. dismissing 2 of the terrorism charges against Luigi Mangione. I mean, I never thought I would say that, but yeah, I missed that time too, Grace Base. Thanks for being here for twice today. Michelle says, Turtleboy said he's going to expose the F out of this judge. Yes, he did. He did agree the other night. Maybe it was even last night. I don't know. The days are all bleeding together now. That he would cover this case now. Originally, he said he wasn't going to because she's represented by Tim Bradl and he didn't want to feel like he was showing any bias. But he said now he's so mad that he's going to. Margaret says, I have gold level 3 severe COPD and had broken ribs. It's extremely sore with permanent cough. They do not get a chance to heal. They don't, Margaret. They don't. There's nothing you can do for fractured ribs. You can't put a cast on them. You can't immobilize them. You can't stop breathing or coughing or sneezing. You just have to let them heal. Kay Anderson says, every state has a disability protection and on advocacy organizations. Massachusetts has the Disability Law Center in Boston. Maybe they should chime in here. Maybe we need to get some amicus curiae briefs in here, huh? All right, let's see General Law 276, Section 58A. All right, this is a long one. Section Conditions for release of persons accused of certain offenses involving physical force or abuse. Hearing order review. I'm going to pull it up for you so that the rest of you want 58B? I was going to start with 58A and then move on to 58B, Music for My Soul, but you are Music for My Soul. Let's see. Okay, good. Let's look at 58B. It's a good place to start because she just did revoke her bail. So this is the Massachusetts General Law statute. Wait a second. I did that the wrong way. Hold on. This is the Massachusetts General Laws, Section 58B, which says or is entitled oh, shoot. I'm sorry, LS. I just deleted your super chat by mistake, so let me read it real quick. Her lawyer can make the jail medical prove they are treating her conditions by FOIA of her medical chart while use that and ADA law in a motion. Thank you, LS. Thanks for your 5. Okay. 58B is entitled Revocation of Release and Detention Order Following Violation of Release Conditions. Oops. Section 58B. A person who has been released after a hearing pursuant to 58A, which is what she was, and who has violated a condition of his release. Okay, she didn't violate it, remember? She didn't violate it. The probation officer said she didn't violate it. So right there, the judge is just sua sponte saying that she violated it. That's not what the evidence shows. Joe Law, they do not offer that ankle monitor in Massachusetts. They don't do it for they don't have them. Shall be subject to a revocation of release and an order of detention. The judicial officer shall enter an order of revocation and detention if after a hearing, the judicial officer finds 1, that there is probable cause to believe that the person has committed a federal or state crime while on release, or clear and convincing evidence that the person has violated any other condition of release. She's saying that she violated the alcohol monitoring scram order. And 2, the judicial officer finds that there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any condition or combination of conditions of release. How many times did she say in that order, I have to assure the safety of the community and the safety of Officer Noonan? How many times? About 1 million, because it's right here in the statute, 58B. If there's probable cause to believe that while on release, the person committed a federal felony or an offense, well, she didn't do that. So we can skip that paragraph. And that's the whole thing. That's 58B, right? Music to my soul. So she's focusing on the second part and ignoring the first requirement. She can't do that. Well, I'm pretty sure Tim Bradl, having met him for the first time on Friday night after the at the Wilbur and after the Wilbur show, and spending many hours talking to him about the First Amendment and all the Constitution, I am sure that he is going to bring this to the SJC. Too sweet, too sweet, too sweet. I would imagine. I know how passionate he is about the Constitution, and I am sure right now that he has steam coming out of his ears. And Monj, thank you for your super sticker, sweetie. And Karaoke says, I'm so glad that you are covering this. Where else could I be? I cannot cover this. I can't not cover this. I mean, I just got a hold of this order, and I only gave you 30 minutes notice because I wanted you guys to get notifications. Otherwise, I would have just came on here. And everyone was like, are you going to cover the thing on the Tyler Robinson thing? It's happening. I'm like, no, this is my thing. This is where I am. This is where I am. I'm not covering that stuff. And I'm not saying that that stuff is not important. But what I'm saying is that I am already neck deep in Kelsey Fitzsimmons, that there is no way I'm going to abandon her now. And we can watch that stuff later. And I watched the presser earlier. And I watched the DA from Utah speak. And I encourage you to watch it, because he gave me some hope in district attorneys, because he said, after revealing all of this horrific evidence they have against this guy whose parents turned him in or had him surrender himself, he said, I am of the belief I do this for justice, and he is innocent until proven guilty. And he went on and on and on and on. And it gave me some more faith in our justice system. So I urge you that if you have not watched that presser from Utah from a little bit earlier today, to please go do so, because it will give you hope. And then before you do that, watch the best moments of Judge Frank Caprio on YouTube. You can find it. Just Google it on YouTube or search it on YouTube. And if you can, again, please give to Kelsey. Every dollar helps. I don't know what we can do to lift her spirits. I am just, I don't know. You know, I heard that they also, when they had the order to take her baby away, and this is going to hurt you, some of you more, that they wanted to take her dog away too. What do we do? There's nothing worse than sitting here feeling so helpless about this and just being a loud attorney who screams into a microphone. Yeah, they want to take her dog away too. Expert architect says attorney Andrew Myers is from North Andover. He should know this judge. I also designed the North Andover fire chief's house, but I haven't heard anything. Expert architect. Did I ever tell you that Zillow is my, well, on YouTube we have to call it corn, but that's my corn, is searching Zillow and just looking at all the fabulous houses. And has Andrew Myers spoken about this case at all? I bet he hasn't. I bet he can't. He can't, because he's going to have to appear in front of this judge. I'm in New York. I can say whatever the hell I want. I don't have to go there until I go to court and show up in the room. And when I did go the one time to the Karen Reed trial, I only went one day. It was June 14th of trial number 1. Judge Cannoni, and I was there with Mark Betterow, knew exactly who we were. She knew exactly who we were. So when I show up to court for Kelsey Fitzsimmons, I don't know if this judge will know who I am or not, and I don't really give a flying. Because she's not scaring me. And they tried to shut me up on Karen Reed. Boy, did they try. You try to shut me up, I just talk louder. I got a microphone and it's a pretty decent one. That's awesome, expert architect. Thank you. James says, I love you, Melanie. Thank you for covering this. Thank you for being interested in enough to watch, James. Muserlina V says, adding Massachusetts to the list of places I'll never live. What the hell? Oh, girl. If you haven't been here, we've been ever since Karen Reed. We've started a side quest of all of these other Massachusetts cases. We saw Penny McGee on trial for manslaughter for having a verbal argument in the foyer with her ex-husband that she was still living with, or he let her stay there because his brothers kicked her out of her house that they owned. She had a verbal altercation with her husband, and he dropped dead of a heart attack. And at autopsy, he had like a 90% occlusion of both descending arteries, and also many comorbidities, including diabetes and dementia. And he had been in a major car accident, and they charged Penny McGee with manslaughter because the whack job ME, and she was an whack job ME, came in and testified that in our handbook, or whatever text she was talking about, whatever guidelines of, autopsies and being a medical examiner, it says that if there are two people in the room and one of them dies, it can be considered a homicide. And that, my friends, was a bench trial in front of Judge Cannoni in Norfolk Superior. And Larry Tipton was Penny McGee's attorney. He's now representing Brian Walsh, and he is the best. I'm going to go out on a limb and say he is the best public defender in Massachusetts and the most humble man that I've ever had the pleasure of emailing with. Because after Penny McGee was acquitted from the bench by Judge Cannoni, Judge Cannoni didn't even take like a timeout to go decide. Like, she acquitted her from the bench. And if you haven't watched that trial, it's only like 4 episodes because it wasn't televised. There were only little pieces that we could pull from wherever, but we did get to see her acquitted, or we listened to it. I think we only had audio only that day. It might have been Zoom. I don't remember now. He was amazing. And she was acquitted. And Penny McGee has started to rebuild her life. She's probably off doing that because that was on her plate for years and years and years and years, because her 2 ex-brother-in-laws are super wealthy. One's from Greenwich and one's from somewhere else, and they got tons of money to throw around. And that's the reason that case was brought, in my opinion. And Larry Tipton, after that was over, I asked him to come on the show. And I said, please come on. The people want to talk to you. We want to talk to you. We want to thank you for what you did for Penny McGee, because he did not have to take her case. She wrote him a letter and she pleaded with him and said, please take my case. And he took a look at it and he's like, of course, as a public defender, which, as you know, in Massachusetts, their public defenders are paid something like $65 an hour. I don't know what's going on with that strike. Are they still on strike? I don't know. And I asked him, I said, please, would you come on the show? And he said, I really would love to. He said, but I get nervous, like, speaking in places other than the courtroom. And I don't think it would be good. I just can't. And I said, I totally respect that. And thank you for everything that you did for Penny McGee. And yeah, I could see why you might not want to visit. FKF 2025 says, oh, look, you changed your name and you put the thing, you're the one who you sent me. I'm sorry. I'm like, so spun. You sent me the logo that is your thumbnail username. What do you call that thing? Profile picture. It says free Kelsey Fitzsimmons, #FKF. If something, I am an authorized service center for Lifesaver ignition interlock and scram. She needs to get a doctor's note stating she's unable to use the breathalyzer and state his recommendation. Well, she did. And the judge didn't give it 2 rats' asses. The judge just didn't care. And they also do not have that scram device, because if you're an authorized service center for scram, they have an ankle monitor that will test alcohol through perspiration. They don't use that one in Massachusetts. The only other alternative was the urine testing. And if you're late tuning in, then you might not have seen that the judge just didn't care about any of it. She just didn't care. She has no heart. We're gonna not really do a poll, but you can throw your suggestions in the chat. Fill in the blank. Judge Kathleen McCarthy Naaman to Judge Bev. Hey, Bev, hold my blank. Pick a drink. I used to say that Judge Cannoni or Judge Gull would say to Judge Cannoni, or reverse. Now I don't even remember. Judge Bev would say to Judge Gull, hold my White Claw, babe. I'm going in. Watch me. Hold my White Claw. We can't use White Claw again. I can't allow it. We got to use something else. What do you think Judge McCarthy drinks? McCarthy Naaman. Hold my robe. Hold my evil spirit. Usually it's like hold my beer, you know? So I was thinking of another one. We don't have a playlist for this. I don't even know if I can gather the strength to do it. Hold my witch's brew. Hold my witch's brew. Yeah, what do they make in the cauldron? Hold my tail. Hold my tail, Cal. Hold my witch's brew. She's a Cannoni Gull hybrid. Hold my high noon. She acts like she's smoking whiskey. Oh my God, talk about smoking whiskey. I just watched if you haven't watched the Charlie Sheen documentary, hold my broom. It's like Woodford. 4 fingers of Woodford. Straight up, not even with rocks. Please don't insult the witches. Mandy says clearly she drinks vinegar. Absinthe. Hold my absinthe. Hold my boxed wine. You guys are good. We need a laugh. Sometimes we need a laugh. Hold my fireball. Hold my tequila worm. I just $100 says the judge doesn't play grab ass, says Scott. Straight up gin martinis, says Andrea. Gin makes you crazy, which is why I prefer a vodka martini. But everyone I ever know drinks gin. Gin makes you crazy. It's made from, the berry that makes you crazy. Hold my Franzia. Guys are on fire. Keith says, let me handle this. If you know, you know. How about since I have college kids, hold my Borg. Does anybody know what a Borg is? And I tell my girls, I said, I better never, ever, ever see a picture of you holding anything that resembles a Borg. Was there any prosecutor in this hearing? Yes, there was. Yes, there was. Blackout rage gallon. That's what it's called, a blackout. Is that why it's called that? I didn't know the lore behind why they call it a Borg. It's a blackout rage gallon. Wow, look at that. I think our demographic is skewing a little bit younger. Thanks a lot, agita. This whole thing gives me agita. I got everything. I got heartburn. I have chest pain. I have palpitations. I have all of it. Caroline said, I've had a Borg. It was the worst mistake of my life. Jason, who needs a prosecutor when you got a judge like this? Robin Rowe wants to know what a Borg is. Somebody let Robin know. Tag her. I'm out of excuses, you guys. I got nothing. I got nothing left. My tank is empty. Thank you, Matt Munch, for another super sticker. Karaoke. Oh, maybe I covered that before. Thank you so much. From Canada. No Love of the Traveling Trooper says, they can't shut us all up. We are here with you. That makes my heart very happy and very full. Thank you. God love your passion, says Betsy. I've been called all kinds of things, but thank you for appreciating it. And see, the people who appreciate it are the ones who stick around. Oh my God, I'm Gumby, damn it. I'm Gumby, damn it. Are you kidding me? I love that username. I'm Gumby, damn it. Says, hold my Everclear. Listen, I went to school in Colorado. There was a lot of Everclear going around at that time when I was in college 100 years ago. And that was a big mistake. Didn't take a lot of Everclear, but to do the deed. And thanks for the reminder. No, love of the traveling trooper. Loves my passion and cupcakes. Thank you. Cheech. Hi, Cheech. It was so good to see you on Friday night. That was a happy night. This is a very, and last week we were all up and down with Kelsey. Like, she got out of jail on Monday. And then, all this was going on, in, out, in, out, in, out. And then Friday night, I think she had just been put back in jail. And then we had Friday night and we needed to laugh and we needed to celebrate something for 10 minutes. And it was good to see you, Cheech. Says, this is so beyond disturbing, and I will absolutely be on the sidewalks courthouse here in Massachusetts to show support for yet another corruption case. Thank you. And thanks for being here for 19 months. And thanks, Drama Mama, for your super sticker. I appreciate you guys so much. Angel Australia has been here for 7 months. Is heartbreaking, inhumane, and somehow I'm shocked. I know. Every time we cover a new case and we think, hold my natty, good one, me members. We think it just can't get worse, and then it gets worse. Because so many of you in the chat are parents. And so many of you know what it's like to have a newborn and to have your newborn ripped away from you. Like, I am, on one guy's with an agenda word. El Dente says, those are so faulty. Interlock BS. My son blew after a pizza, couldn't start his vehicle. It's about the money. Well, this is not a blow. I know I called it a blow and go, but it's not. Those are the ones that are attached to your ignition. And people say those are really, really hard to blow in. This is different. This is like a handheld remote. And I think it has facial recognition to make sure it's the right person, like blowing into it. So it is a little bit different, but it may be made by the same company. Thank you, Al Dente. Costco Prosecco. Hold my Costco Prosecco. Says M169. Thank you for being here for 4 months. In New York, they don't sell liquor in Costco. New York has really weird liquor laws. You have to go to a liquor store that has a liquor license to buy liquor, and you can't buy beer in a liquor store. You can buy beer at 7-Eleven or the gas station or the supermarket, and we don't allow wine or liquor to be sold in like CVS. Like, I go to California and you can buy a bottle of wine at CVS, which I find to be wild because here it's very strict. And so some Costco's do have liquor stores. Actually, maybe we do have Costco liquor stores here. I could be wrong about that. Maybe there's one like on Long Island, but like in California, like I said, you can buy wine in supermarkets and CVS. Cheryl says, hold my box wine. Thanks for being with me for 10 months. Love you with all of my heart. I just don't even really know what else to say about this, except I'm outraged. I hope you're outraged, and I hope together we can do something about it. We can channel it into something that makes a difference, because that is what I want for this channel. It's really the only thing I want for this channel, is to bring attention to things that need attention, to give a voice to the voiceless, and to be loud about so many things and so many injustices that are not necessarily the popular cases that everyone's covering, but that I think that people need to know about. And so thank you for putting up with me and for being passionate about it. Again, Kelsey's Give, Send, Go is in the, I haven't seen the mega motion yet today. That would help our anger, but I don't know. They were neck deep in redactions earlier. Olivia was working on it. So I don't know if it was able to be filed today. I don't know if they have e-filing in Massachusetts. I don't know if you can e-file. I think somebody has to physically go to the courthouse. If anybody's in the house, if anybody's here in my house that knows, you can let me know. I don't think you can e-file in Massachusetts. I think you have to go to the courthouse and file. So I don't know if it got to be filed today. So, but if you're going to watch Aiden's show at 9:00, which I certainly, of course, would recommend that you do, maybe he'll be able to talk about it a little bit. And thank you, Susan, for your very generous Venmo, who just says masterpiece. And that reminds me of a Grateful Dead song, which is a cover tune, When I Paint My Masterpiece. I think it's a Bob Dylan song. And maybe many of you may know that song, but I'm going to go listen to this as soon as we get off here. When I paint my masterpiece. Someday everything's going to be different when I paint my masterpiece. Bob Dylan is the one who wrote that originally. Oh, the streets of Rome are filled with rubble. Ancient footprints are everywhere. You can almost think that you're seeing double on a cold, dark night on the Spanish stairs. Anybody know? Brings a tear to my eye. All right, I think I'm tapped out. I think I'm tapped out today, and this is the second time we've been here. If by some stretch of the imagination, Alice, thank you very much for your Venmo. Says nothing nefarious here for all your time you spent brightening my day. I love your intelligence, wit, and beautiful soul. Did not send through the super chat, even though I'm a subscriber, because, well, if you know, you know. I know YouTube takes 30% of super chats. A lot of people don't know that. And also, if you, I just fell into this rabbit hole, which is a whole story for another day. But if you're on your phone and you send a super chat, if you're on an iPhone, Apple takes like 30% off the top. I forget what their VIG is. And then the balance goes to YouTube, and then YouTube takes 30% off the top. And I don't care. I'm not here for super chats. I don't care. But I just think a lot of people don't know that. But thank you, Alice. Retired accountant. Rest in peace, Robert Redford, who I think was probably my first crush. Let me tell you, I'll tell you a quick story about Robert Redford. Because it's a fun, heartwarming story. Thank you. Hold my buzzball, Bev, says Noelle. Lala says, ever try Purple Passion by Everclear 2-liter bottle? No, hell to the no. I tried it once by mistake in college. I think somebody put it in punch, and that was it. Yeah, exactly. Timely manner. Thank you, Mel. We've been here before. We can do it again. Free Kelsey Fitzsimmons. No, I'm Gumby, damn it. Coming in hot. Judge drinks Ballantine. Have a Schlitz or PBR. Ginny says, my go-to sub for flying F is Flying Fig. That could work for you. Flying Fig, I'll allow it. All right, let me get this witch off my screen and tell you a little story about Robert Redford. And my sister told me this story this morning, and I'm going to tell you the story without naming her because it's about her. And when she met Robert Redford, wait, hang on, I got to get to the proper family group chat. She's in the business. She's in the business of Hollywood, and she said he also went to the University of Colorado at Boulder, which is my alma mater. And I know he spoke at one graduation, but it was not mine. And I was sad because, he was like my first crush ever from Butch Cassidy and the Sundance Kid. My sister, who will remain nameless, said, when I saw him speak, Robert Redford, it was on behalf of the Sundance Channel at the Chateau Marmont for the upfronts. And I had met him in the driveway walking in right before. I told him that I had been waiting my whole life to meet him, and that we had bought a house in Park City when there was only one traffic light in town, and that we'd been to his resort and to Zoom. And we did. My family had a house in Park City like years ago, and we grew up skiing there. I was sitting at one of the tables in the front of the room. So when he spoke, he said, my friend, and then he named her first and last name over here, remembers when there was only one traffic light in Park City when the festival first started. And the heads of the Sundance Channel who had invited me almost died. It was crazy. That's the way people like him do things. They later got a photo of me talking to him and framed it for me. It's not a great story about Robert Redford. It's not like heartwarming. I love that story. So now I'm going to bid you adieu. For now. Where do you want me to send you? Let's do a cupcake invasion. Hang on. I don't know who's live right now, but I will check. I saw that Mike from Young Jerks went live around the same time I did earlier with Betterow, and I don't know if they're still live. So let me just see if they are. I will send you there. Hang on. if he allows it. Some creators don't allow redirects, and so I can't always redirect you everywhere. But yeah, it looks like they are still live. So I will send you over to the Young Jerks for a cupcake invasion. And so, tell them we say hi. And I'm anxious to. They're talking about Kelsey. Okay, I'm anxious to get over there and see what they're saying. I'll probably have to rewind. So it's been a hard day. It's been a really hard day. Stay cool, stay kind, stay classy. I love you. I love you for supporting Kelsey Fitzsimmons, and let's just keep on keeping on, because that's what we do. That's what we do here. This is the way we roll, and this is how we do it. All right, my guys. Peace. I'll see you tomorrow. Cupcake invasion. Buckle your seatbelts in 3, 2,